Hey NoteTakers, welcome to my YouTube channel. If you're a returning viewer, thank you for tuning in and welcome back. If you're a new viewer, welcome. I hope you enjoy the videos because we have fun this side. If you're a subscriber, thank you for subscribing to my channel. If you aren't a subscriber yet, what are you waiting for? Click the subscribe button to join in on the fun. Don't be shy. Alrighty, let's get into some case law. So on today's video, I will just be going through my background, my little disclaimer, the playlist for this video. I will be going through a case by applying my 3 model case law steps, and then we'll have some closing remarks. Alrighty, just some background on myself. My name is Ria Betty, but I prefer Ria. I am currently a 4th year UNISA BA law student, just wanting to engage with other law students, individuals who are lovers of the law, soccer fans, and to connect with viewers from around the world. If you have any content suggestions or just wanting to reach out, feel free to email me at rianotesid@gmail.com. Again, my channel email is rianotesid@gmail.com, where you can share your law student experiences and share some feedback. Also, as I always say in my videos, make sure to check my YouTube post section regularly. I did put up a post last week. I think it was the 8th of August, explaining that I wasn't able to record. I was having some network issues. Yeah, I was really sad about that. So this video is for the 15th of August because I try and post new videos every Friday. So maybe you might have seen I hadn't posted a video, or maybe not. So just check my post section regularly. But the positive of not being able to post, which is like such a juxtaposition, I was able to sit down and watch Wednesday, and I really enjoyed it. It was fun going back to Nevermore and seeing everyone, because it's been over 2 years since the first season, I think. So yeah, it was really fun seeing everyone, Wednesday, family, and if you guys hadn't noticed, Ajax, I love Ajax, I'm team Ajax. So yeah, it was really fun. That was the positive. I'm trying to see the positive in the negative. But yeah, so if you guys watched Wednesday, just let me know what you guys think. Because I do want to, I don't know, do like a Wednesday episodes preview, I don't know, of season 1 and 2, I'll see. But I don't know, I felt a bit let down over the whole avian plot twist. I don't know, that's just how I felt. Maybe part 2 will be a bit better. And I feel like Enid is doing Ajax wrong. I don't know. I feel like a character feels a bit different this season. I don't know. But yeah, I'm team Ajax all the way. So yeah, we'll see what part 2 brings, which I think is coming out in September. But yeah, team Ajax all the way. Yeah, I just want to take a second to just really, truly, from the bottom of my heart, say thank you to my subscribers. You know, everyone who's subscribed, everyone who's liked my videos, who's commented, it really means a lot. I think I gained quite a bit of subscribers when I was doing Real Housewives of Atlanta content. So that was really fun. And I don't know, I like choosing a month and being like, okay, this month I'm going to be doing this topic, and in that month I will just do that one topic. So that's what I did in July. I was like, okay, it's going to be Real Housewives of Atlanta month. So I had to go back and rewatch episodes, certain seasons, certain reunions, and I posted shorts that was purely Real Housewives of Atlanta. So there will be times where I just pick a month and be like, it's just going to be that content. This month, I'm just going to be talking about Tammy Taylor stuff and case law. So I don't know if people are interested in case law, but I'm just doing content that really excites me, interests me, and I don't know, I love case law. Anyway, we went on a tangent. I just wanted to say thank you to my subscribers. I think we're on 390 subscribers. So we're on the road to 450. So first of all, thank you to all of my subscribers. Thank you to all the viewers who are watching, commenting, liking, sharing, subscribing. But yeah, I really want to do something like for the month of September, because it really helps me zone in and just focus on that. And yeah, I just really like that format because it helps me, be a bit more organized in my brain. So we're on the road to 450. So please keep commenting, sharing, liking, subscribing. It truly means a lot. Truly, when I saw that my subscribers were growing, I got a tad emotional because this is my job. So thank you to my subscribers. Thank you, thank you, thank you. And let's all say my channel mantra. Ria knows it will grow. Ria knows it will do well. And Ria knows it will reach my people. So we're on the road to 450. So keep commenting, keep sharing, keep liking, keep subscribing, and let's grow the NoteTakers community. So on today's video, I am going to be discussing a case, and I don't know, just as a safety precaution and just trying to be safe legally, I have this disclaimer notice, just saying that I am discussing cases in my capacity as a law student. I'm not an attorney or a lawyer or an advocate. I'm just purely doing it out of curiosity. I'm just a student discussing cases, acting in good faith, i.e. not malified, bona fide. I am discussing cases by making use of my knowledge as a law student and making use of my own opinion. So again, I'm discussing cases in good faith from a law student perspective. So just for safety. Okay, so this video will go under the Ria Cases It playlist, where I just go through cases that interest me. So feel free to check the videos under this playlist. Yeah, and let's just have fun with case law. It's fun. So I came across this case because I was watching the news, and Tammy Taylor, Malfillion, and Beardfillion, they were just in the news everywhere. So I was just like, I got curious. I was like, what is happening here? So hence, that's why I'm doing this video. So I just want to start by talking about who the Fillions, or Mal and Beat Viljoen are. So let's start with Beat Viljoen. He was a lawyer, but he was struck off the roll in 2011. I don't know if our South African version of being struck off the roll is the equivalent of in America, you know, when you're disbarred. I don't know if it's similar, but yeah, I don't know. Anyway, he was struck off the roll. And then he also appeared on Real Housewives van Pretoria or Real Housewives of Pretoria. And then next we have Mal Viljoen, who she was on the Real Housewives van Pretoria. You can say Real Housewives of Pretoria or Real Housewives van Pretoria, doesn't matter. I went to her IMDb and she was on that roast of Helen Zilla. I still haven't watched it. I'll see how I feel. She was on Ultimate Girls Trip, South Africa, and Real Housewives of Pretoria. So, yeah, that's Mal in a nutshell. This is her on the Real Housewives from Pretoria. So when I saw all the stuff going on in the news, I was like, I want to know what's happening. So I started researching case law in relation to Mal, Beat, and I came across the Tammy Taylor case. So today's case is between Christina Johanna Steynberg and Tammy Taylor Nails Franchising. So that's the case we're going through today. In my studies, I've come to learn that reading court cases is a very good skill for a law student to have, very important. It's referred to as case law because you're reading a lot of court cases that deal with acts, the Constitution, legislation, and statutes. I look at case law as a collection of court cases that, you know, deal with important decisions that will impact future court cases. Just think of case law as a collection of important South African court cases. So the module Skills Course for Law Students, or SCL 1501, it really helped me in understanding how to read a case. My advice is to practice reading different cases to get better, because the more you practice, the better you'll get. So pages 47 to 62 in the SCL 1501 study guide are incredibly helpful. So when I'm looking for a case, I go to SAFLI, which is the South African Legal Information Institute, as we see here. South African Legal Information Institute. So when I'm looking for a case, normally I type the name of the case into Google, then a SAFLI link will appear. It'll come up with the name of the case, then I download the case. Or alternatively, you could go directly to SAFLI, just click the link, and then search in the SAFLI website for the case and then download the case. Whichever works for you, as long as you download the case and are able to read it, is most important. I have developed my own steps that I use when reading a case, and I really hope these steps will help you too, note takers, because reading cases, it kind of has to become a part of your daily bread, especially if you're a law student, if you like work in the legal world. It's important. These 3 steps have truly helped me. I have coined these 3 steps as RIA's 3 model case law steps. Okay, the first step in RIA's 3 model case law steps is finding the case. So I've established that going to Safely will help you in finding the case. The second step is to skim the case. When skimming, usually what I do is I'm like, okay, how many pages is the case? The court the case was held in, the name of the parties, and I check, does this case deal with certain acts? And if I see, okay, this case deals with a certain act, then I will download that act as well, so that I will have the actual case and then the act that comes with it. So in the case when they're referring to a section in the act, I have both. The last step, step 3, is the deep dive. Basically with step 3, I start to read the case obsessively, meticulously, and I try to be as thorough as I possibly can. Start reading from the very first paragraph to the last, almost to a point where I know the case off by heart even without reading it. Like even with this case, like there are certain paragraph numbers that are stuck in my head because I've read the case a lot. And I make super detailed and thorough notes. And where I find a paragraph I deem interesting, I will write down the paragraph number. I think writing paragraph numbers down is important because sometimes when you're doing an assignment, you might have to go back to an important point and you might forget what paragraph number that was. So just try and develop a system. I also sometimes like to take a piece of paper and like literally fold it in half. So one half will have the information of one party and the other half of the page contains information of the other party. I also do that when I'm like studying for an exam and I'm like, okay, in my exam I'm going to refer to this case, so I need to know this case off by heart. I do the whole folding in half method, and when I'm studying like repetitive, and then when I write the exam I'm like, oh, I remember everything I wrote down. I don't know, it's just become second nature. So hopefully RIA's 3 model case law steps help you as you read court cases. Remember, step 1, finding the case. Step 2, skimming the case. Step 3, deep dive into the case. So let's apply RIA's 3 model case law steps to today's case. Alrighty, so step 1, I made use of Safely, as you can see here. I searched for the case, I found it, and I downloaded it. Because I knew the name of the case, I just typed it into Google, and then this came up, and then I just downloaded it. If I didn't know the name of the case, I would have gone straight to Safely. But I prefer Googling the name, then downloading it at Safely. Okay, so now we can start reading the case, now that we have downloaded the case. So we move on to step 2, skimming. Remember skimming, we look at page numbers, what court the case was in, the parties, and so on. So the case is 28 pages. The case was held in the High Court. The parties are Christina Joanna Steinberg and Tammy Taylor Nails Franchising, and the case deals with the Consumer Protection Act, which I downloaded because when I was skimming I was like, okay, Consumer Protection Act, so it also like saves you time. Again, pages 47 to 62 in the SCL 1501 study guide are extremely helpful. Okay, so now we move on to step 3, which is all about reading the case while making sure to write paragraph numbers that you deem important. Okay, so now that I know the parties of the case and that the Consumer Protection Act is needed, I can now dig deeper. So now we know the parties. So if we look at the applicants, they can be described as he who brings the application. In this case, the applicant is Christina Johanna Steynberg. From here on, I will refer to the applicant as Steynberg. Then we look at the other party, the respondent. They can be described as he who is responding and objecting to the application that's brought by the applicant or the plaintiff. In this case, the respondent is Tammy Taylor Nails Franchising. From here on, I will refer to the respondent as Tammy Taylor Nails SA. Okay, then we look at the judge that's in the case. So just remember that AJ stands for acting judge. So in your skills course module, like there are certain abbreviations that you need to know, because when you're reading a case, automatically you need to know what this stands for. So that's what I say: practice, practice, practice. Okay, so Steynberg, the applicant, they basically want to cancel a franchise agreement they made with the respondent, Tammy Taylor Nails SA. So I just wanted to know why the applicant wanted to cancel the agreement. Was the plaintiff unhappy, or was the respondent at fault? Let's start off with paragraph 1. So paragraph 1, it basically explains the origins of Tammy Taylor in South Africa. So I'm just going to take a step back and just explain what Tammy Taylor Nails is. It's basically a company that was started by Tammy Taylor in America. So paragraph 1 says that the respondent, i.e. Tammy Taylor Nails SA, they acquired the right to use the trademark Tammy Taylor Nails. The respondent is the franchisor in South Africa, and they have the right to grant franchisees a license. So basically, Mal Yoon, she is the president of Tammy Taylor South Africa. That's why I was discussing her, and I think her husband also worked at Tammy Taylor Nails SA. Now I have been posting a lot of shorts. If you haven't watched those, please go check them out, because they'll explain in a bit more detail. So that's where Mal and Yoon come in. They kind of operated Tammy Taylor Nails in South Africa. So just remember that Tammy Taylor Nails, it's not their company. It's the company of Tammy Taylor in America. I think Tammy Taylor in America allowed them to use the trademark Tammy Taylor Nails. But something happened, a lot of drama. So this is the first case I've read. I also read another South African case, and then I read a American case that kind of explains everything. So I will be doing a video on the second South African court case and then the American case, so to hopefully understand. So paragraph 1 basically just explains the origins of Tammy Taylor Nails in South Africa and how Tammy Taylor Nails South Africa came to be. So when I was reading paragraph 1, it spoke about a franchisor and a franchisee. So for me, in my opinion, a franchisor is a company that gives somebody a franchise, and then a franchisee is a person who is given a franchise. So in this case, the franchisor is Tammy Taylor Nails, South Africa, and the franchisee is Steynberg. Then we'll move on to paragraph 2, as you can see here. It says the applicant is the franchisee, as I said, in terms of a written franchise agreement that she signed on 19 November 2020 in Pretoria. And then she also paid the amount of 345,000. So the case took place in the High Court, and the High Court deals with civil matters that deal with more than 100,000. So this case deals with amount of more than 100,000. It deals with 345,000. So that's another thing you have to keep in mind when you're reading case law. You have to know the different courts, and you learn that in skills course. So it's a very important module, I think. Okay, so basically paragraph 2 is just telling us the applicant is a franchisee, signed an agreement, paid the money. Okay, then we move on to paragraph 3, where it says here, it became apparent to the applicant that the respondent wasn't open and honest, and because of that, Steynberg elected to cancel the franchise agreement. So the applicant signed the franchise agreement, as we see here, on 19 November 2020, but then on 14 December 2020, the applicant sought to cancel the agreement. So I think that's what really piqued my interest. Even just reading the case right away, I was like, what happened? Why did the applicant cancel the agreement so quickly? Because you sign in November 2020, you want to cancel in December 2020. That's like a month, like not even. So I'd say paragraph 3 really piqued my interest because I was super curious. I wanted to know, why did the applicant cancel the agreement after a month of signing the agreement? Like, what happened? Okay, then we move on to paragraph 4. Basically, paragraph 4 is saying that the applicant, which is Steynberg, she is saying that the respondent failed to comply with various provisions of the Consumer Protection Act. So we see a paragraph 4 mention of the CPA, Consumer Protection Act. So yeah, it was really interesting reading this act. So see that the Consumer Protection Act kind of helps us understand franchises and franchise agreements. Okay, then we move on to paragraph 17. Um, and this is what I actually love about reading case law. You read about different things. Like sometimes there's a case that deals with like medical stuff, like anatomy stuff. Sometimes there's a case that talks about tax stuff. Sometimes there's a case that deals with the Constitution. Um, so you're not only just studying the law, you're also studying other things, which, yeah, it's really fun. So when I read paragraph 17, it was like a blast from the past. So basically, in paragraph 17, it's an email, this one here, that Steynberg sent to the respondent, Tammy Taylor South Africa. So it was a bit of a flashback Friday, throwback Thursday, whatever, like an Afrikaans lesson, because the email was in Afrikaans. So when I was in high school, I decided, you know what, I'm going to take Afrikaans as a subject. And I'm sure like South African people, like in high school, like when you're in grade 10, I think, when you're in grade 10, or 9, I can't remember, you pick between Afrikaans or like Sizulu. So I was like I already know how to speak Zulu, so let me try Afrikaans because I wasn't really well versed in it. And I was like, you know what, I'm gonna treat it as a challenge because Afrikaans was truly a language I did not know. Um, you know, when I was little, like Kamuntlung, you know, you speak Sotho, and then when you go to school, you have to learn English. So Afrikaans was a language I wasn't not at all exposed to until I took it as a subject. I mean, yeah, I studied it in primary school, but I mean, because I had to. So when I got older, I was like, okay, I'm gonna take this on. It was my decision. Um, so I was like, you know what? This is gonna be a fun challenge because, again, I didn't really know the language. Um, so I did everything that I could. There was a point where I was super fluent in Afrikaans. Like I could have like fluent conversations with my classmates, my teachers. Um, yeah, it was insane. Um, but yeah, obviously over the years, I've forgotten some words because I'm not like in it, like going to school, studying it every day. Um, but yeah, it was really fun. It was really interesting. Um, like there's certain words that obviously are like embedded in my brain, like words like verantwoordelijkheid, which is like responsibility. Words like zenuwachtig, you know, when you're nervous. So little words like that. So yeah, just a flashback. I used to be fluent. Like even in the family, it was known. Okay, if you need help with Afrikaans homework, you know, rabbit shooting, phone and WhatsApp, and she'll help out. It was really fun. Um, like I always made sure I got 80% and above for my tests, for my exams. I will say I was better at literature than language. Like literature, like comprehensions and whatnot, most of the time I would get like 100%. But the language was really tricky. Um, I mean, I get 90s and stuff, but you know, I tried my best. So there might be some words I stumble upon. Please don't judge me, Afrikaans speaking people. Um, so this is an email that Steynberg sent to Tammy Taylor South Africa. So if I don't pronounce some words properly, don't judge me. Like I'm trying my best. Okay, here we go. Carla. I'm assuming that's someone who works at Tammy Taylor Nails. Carla, ons het 9 uur 'n redelike groot meeting gehad aangaande Tammy Taylor. Kostes is bespreek, uitgawes wat alreeds aangegaan is, asook sekere spesifikasies wat nog moet plaasvind. Ek en Arie het besluit met al die kostes wat ons nog moet spandeer, soos shopfitting, persoonlike opleidingskostes, uniforms, produkte aankoop, gaan dit nie vir ons die moeite werd wees om aan te gaan nie. Die kostes is meer as wat ons beplan het, en sodoende het ons besluit om die franchise ooreenkoms te kanselleer, voordat julle enige geld ook moet betaal vir Park Salon. So yeah, I obviously stumbled on some words. So I tried translating the best that I could. So basically, the applicant is saying, we had a meeting about Tammy Taylor, the things they discussed at the meeting, and that they basically want to cancel the franchise agreement. So here where it says groot meeting gehad, it means, we had a big meeting. Then where it says kostes is bespreek, I think costs were discussed. I was a bit confused what uitgawes is, but I was like, okay, 8 means going out, so maybe it means money going out, expenses, I think. Next where it says spesifikasies wat nog moet plaasvind. I mean, specificaties is pretty simple specifications that still need to take place. I think plaasvind means still need to happen, like something still needs to happen. And then the sentence, nie vir ons die moeite werd wees om aan te gaan nie. Basically, it's not worth it to go on, because I think the applicant was a bit overwhelmed. Kostes is meer as wat ons beplan het. Kostes is costs. Beplan is what we had planned. Then they say, besluit om die franchise ooreenkoms te kanselleer. Besluit means decided. Ooreenkoms is agreements, and kanselleer is cancel. So basically, they want to cancel the franchise agreement. So that was a fun little Afrikaans lesson. So yeah, that's basically the email that was sent to the respondent. Okay, so paragraph 23, it goes into detail about what was in the amended franchise agreement between the applicant and the respondent. This got me thinking, like, what is the legal, like, South African definition of a franchise agreement? So the legal definition can be found in the Consumer Protection Act. This act basically promotes a fair marketplace for consumer products. The act also prohibits unfair marketing and business practices. So the definition of a franchise agreement is found there in the definition section of the act, because in acts there's like definitions. So here's the definition of a franchise agreement. It is an agreement between two parties, the franchisor and franchisee. So basically the agreement, the franchisor grants the franchisee the right to carry on business under a system or marketing plan determined or controlled by the franchisor. Um, Basically, a franchise agreement governs the relationship between a franchisor and a franchisee, just to protect both parties and to promote a fair um, marketplace. So, my next question was, what are the requirements of a franchise agreement? That's found in section 7, where the requirements are laid out. So, a franchise agreement, which is what Steynberg and Tammy Taylor South Africa were working on, has to be written and it has to be signed by a franchisee. That was the part that confused me. Why only the franchisee has to sign? Why can it not be both? Because remember, the franchisee is given a franchise. Then it says another requirement of a franchise agreement, it has to comply with requirements of Section 22. In other words, Section 22 of the Consumer Protection Act. So this is Section 22, which speaks to the right to information in plain and understandable language. Section 22 basically is just speaking about the right to information and understandable language. Basically, this section highlights how consumers have a right to documents being in plain language, and that the consumer's literary skills or vocabulary skills will be considered. So I think it's just promoting fairness, not putting in tricky language, just in plain language that the consumer will understand. So it says here the producer of a document must make sure that the document is in plain language, like that a normal person would understand. So again, when I read section 7, I was confused by section 17A that says it should only be signed by the franchisee. Why not both parties? So paragraph 25 answered my question. So paragraph 25 of the case says it is open to the parties to agree that the contract will only come into being if certain formalities are complied with. This raises the question as to whether the informal contract is binding and the written document intended for purposes of proof only, or whether there is to be no contract until the written document has been drawn up and executed. So I think this answered my questions, because it says here will only come into being if certain formalities are complied with, like the agreement should be reduced to writing and signed by both the franchisee and franchisor. So not just the franchisee, but both. So can the franchise agreement between the parties be seen as valid? In my opinion, no, I don't think so, because I know from my contract law days that when you're dealing with a contract, certain requirements have to be complied with. Like there has to be consensus, like parties must agree on all material aspects of the agreement. There must be formalities, like it says there, if certain formalities are to be followed, they must be observed. And also possibility, like the obligations to be undertaken, they have to be capable of performance. So paragraph 25 and these formalities are key. Perhaps the parties came to an agreement that the franchise agreement is to be in writing and it has to be signed by the franchisee and the franchisor, but only the franchisee, in other words the applicant, in other words Steynberg, signed. So only one party signed. So that, for me, in my opinion, is the main reason why I think the franchise agreement is invalid, just for me, because I feel like both parties need to sign. So let's see what the judge's reasons are, because the judge came to the conclusion that the franchise agree is invalid and void. So remember, South African law, it doesn't recognize a unilateral contract. A conclusion of a contract is bilateral or multilateral. It has to be between parties. I don't think only one person can sign. It just sounds malified. So in paragraph 27, we find out or read about the reasons that the judge found the franchise agreement invalid and void. So reason number one, the language or words or phrase used. So the judge says the words or phrases confirm that it was required of both the applicant and the respondent to sign the franchise agreement, and that mere signature by the applicant will not suffice, which I strongly agree with, because it's known in contract law, both parties have to sign. So I agree with that. Reason number two, just basically spoke to the respondent's contradictory nature. So on one hand, the respondent admits, okay, we didn't sign the franchise agreement, and that's okay. But then on the other hand, the respondent is saying the formal requirements were met. It's contradictory, because on one hand, you're saying we didn't sign the franchise agreement, that's right. But then on the other hand, you're saying that formal requirements were met, which isn't true. So you're contradicting yourself. Which is it? And then reason number three, the respondent failed to reply to emails. So the applicant sent numerous emails requesting a copy of the franchise agreement with the respondent's signature. I don't know why the respondents failed to sign the franchise agreement. It's just, I don't understand why you don't respond to emails. It's just weird. So the judge said it would have been the most easiest thing in the world. And I agree, responding to emails, pretty straightforward. Just answer your emails. So the fact that the respondent failed to sign the franchise agreement makes the agreement invalid and void. So those are the judge's reasons. Reason number one, the language used, both parties had to sign. The respondent's contradictory nature and not responding to emails. The So the conclusion made by the judge is that the respondents failed to sign the franchise agreement, making the agreement invalid and void. But now the problem is the applicant paid $345,000. So that's a problem. So the applicant clearly sent many emails to the respondent, so I just want to do a quick timeline. So 19 November 2020, Steynberg signed the franchise agreement and forwarded to the respondent. December 2020, sent an email, I think just asking about building plans and stuff about the store. The respondent replied. 4 December, the respondent replied by email. 10 December, the applicant sent an email asking questions about the interior and layout of the business. 14 December, the applicant wanted to cancel the amended franchise agreement. It's that Afrikaans email. So that was on 14. 15 December, followed up because they want to cancel. And then 19 January, the respondent's attorney sent a letter. So the applicant sent a lot of emails to the respondent, which I feel like it was really unnecessary. Like, I see why the applicant was frustrated. Like, felt like the respondent wasn't working with them. So when I was reading paragraph 29, I felt like I was having like an enrichment lesson, justified enrichment. So yeah, I really enjoyed enrichment. My average was, I think it was 95. I think the first assignment was a written assignment. I really was anxious about this assignment because I did so much research. Yeah, it was a lot of research, a lot of case law. But I passed, I got 100%, and then this was a quiz. It was really draining. I can't remember. Either I got 78 or 88, somewhere there, for my exam. But it was a really fun module. I really, truly enjoyed it. So, in paragraph 29, I was like, okay, let me remind myself of the general requirements for enrichment liability. 1, the defendant must be enriched. 2, the plaintiff must be impoverished. 3, the defendant's enrichment must have been at the plaintiff's expense. And lastly, there has to be some legal cause. So let's apply the general requirements to the case. Okay. The respondent is enriched. Defendant. The applicant is impoverished because the applicant has 345,000 less. And that leads to number 3, the causal link. That it is because of the respondent that the applicant is impoverished. So had the applicant not paid the 345,000 to the respondent wouldn't have been enriched. The respondent's enrichment is, sadly, at the expense of the plaintiff, Steynberg. Then number 4, in my opinion, I feel like there's no legal cause because the respondent didn't sign the franchise agreement, so there's no legal basis for that 345,000. So it says the applicant signed the agreement in good faith and paid. But the respondents didn't sign the franchise agreement, and the judge found the franchise agreement invalid and void. So I feel like there was no contract because the respondent didn't sign. So yeah, the applicant was impoverished. So what did the judge order? So first, the judge said, okay, the franchise agreement is invalid and void, mostly because I think the respondent didn't sign. The respondents weren't really helping the applicant in any way. And also, the applicant was really impoverished. 345,000 is a lot of money. Then it says the respondent, in other words, Tammy Taylor South Africa, they are to refund the applicant 345,000. So the applicant can get her money back. And then the respondent shall pay the applicant's cost of the application. Because really, truly, the respondents, I feel, put the applicant in a worse off position than she was before. So hopefully the refund will put the applicant in a better position than before when she paid the franchise license fee. So I feel the respondents, Tammy Taylor South Africa, which is like an extension of Mal and Beetviljoen, they really treated the applicant unfairly. The respondents failed to sign the agreement. They didn't really help the applicant. Kind of felt like they just took the applicant's money and then just left the applicant with no help. So I really do believe what the judge ordered was fair. The applicant needs her money back because the respondent isn't really helping at all. So yeah, this case was really interesting, but just really unfortunate about how the respondents preyed on the applicant. Alrighty, I've gone through the case and analyzed it to the best of my ability. My analysis might not be perfect now, but I tried my best. Feel free to leave a comment in the comment section or share your views by emailing me at rianotes@gmail.com. Again, feel free to check out my shorts on Tammy Taylor, Malviljoen, Beetviljoen once you're done watching this video. So I'm working on another video dealing with a different case with another plaintiff, but the same defendant, Tammy Taylor South Africa. So watch out for the follow-up video. So in reading the South African cases, I started to understand why Tammy Taylor of Tammy Taylor Nails from America was aggrieved, because she had cancelled Malviljoen's right to use the trademark Tammy Taylor Nails, but it seems Malviljoen ignored that and continued operating Tammy Taylor Nails South Africa, which I feel is illegal, because if someone ends something, you can't do anything legally. So I will have another case, but with Mal and Beetviljoen. If you're a regular viewer, you know I hate littering. My mantra has always been, stop littering. Please stop littering, note takers. We only have one planet, so let's all do better, stop littering, and look after our planet. Don't let her do better. Alrighty, I hope you guys enjoy this video. Don't forget to comment, like, share, and subscribe. I am the CEO / employee / boss, and this channel is my daily bread. It's my job, so help a lady out by subscribing. I'm on the road to 450 subscribers, and again, thank you to all my subscribers. I hope you guys will stay tuned and that you watch my new videos. In closing, I shall say first, thank you for listening. Second, don't let her do better. And lastly, see you soon. Thank you so much, note takers. Until next time.